come forward here on this 19-3170A. There's a motion to revoke probation that's been filed, which alleges that you have been placed on deferred or unadjudicated probation for the state jail felony of illegal possession of a controlled substance. That was in 2019. What's happened? Was he an absconder?
He he violating, was taken out of the safety.
He relapsed, Ron.
We sent him to safety and then he came back, he relapsed, we sent him to safety.
No, hold on.
relapsed.
He was on probation for 5 years
You
since
extended-
2019. Oh, it's not showing that it was extended.
You extended it on June 10th, 2020.
Okay, because the way this reads, he completed probation 2 years ago, actually, yeah, 2 years ago, right at 2 years ago, according to this, because it doesn't show anything about anything past 5 years deferred, which would have ended in 24. Is that right? Your probation was extended for how long?
2 years, Judge.
All right. So it alleges you failed to avoid disreputable people by being around those actively smoking marijuana. You provided urine samples that showed the presence of drugs. Urine samples showed the presence of alcohol. Urine sample, cocaine and tetrahydrocannabinol. Failed to submit to alcohol and or drug screening. Failed to pay court assessed fees as directed. Failed to enter and successfully complete the substance abuse felony punishment facility back in July of 24. There's 8 different violations. Only takes one or more for the court to find that you've violated the probation. You could then be found guilty and sentenced up to 2 years in the state jail. Do you understand what you're facing?
That's right.
Okay, all right. So what are we going to do?
Judge, like you just asked when we would be ready. Again, I do need to make sure that we have Spindletop available to discuss mental health records. Aside from that, I believe we were set today on a bond request. It's unadjudicated probation. I understand there are concerns if the court did proceed with instituting a bond. The concern from a perspective of the mental health caseload is whether or not his conditions are being adequately addressed while in custody. And so I think that's going to have to be better explored. Obviously, there is no.
Why don't you do that? You're going to represent him. I'm not going to be able to figure that out. Isn't that your concern? Because I'm going to listen to whatever you have to say. What do you have to say about it?
About
what do you want me to
mental health
do?
Concerns? Or I'm asking for a bond, Judge. I thought I had made that pretty clear.
No, I'm talking about his mental health concerns. What is it you want me to do?
As far as his mental health concerns right now, I don't need the court to order anything.
Okay. All right. What are you asking for here? Exactly. Just a bond of any amount.
In terms of an amount, what am I asking for?
State, what do you have?
Judge, I'm concerned with all these positive drug tests and the fact that safety doesn't look like it worked. So I would ask the court to, whatever bond you set, to take that into account, specifically for his own safety. As far as I'm concerned, when he's out there, he's using drugs. I can be ready quickly. I would rather it stay at the state that it's in now. These are administrative violations. The state's ready to have a hearing.
I know typically when there's a bond issue on a motion to revoke deferred, it's usually anywhere from 1/2 to twice the original bond.
Never look at that. We look at what's new,
I think
probation
just,
and what he's done, because those are all new. That has nothing to do with the original law. It's how he performs. That's new information that is part of the calculation. Oh, where you got that?
I wrote down in my notes that this young man is lucky to be alive. Just looking at all the drugs that he's been using there, I don't want to take the chance that he's not going to be here for a hearing.
It's probation.
I've worked with Mr. Castillo for some years. I was his QMHP at Spindle Tap. He's been on the mental health caseload several times. Since being his probation officer, he came back from St. Pete. He relapsed less than a month later, went back to St. Pete recently, 30 days, and he used while he was there. And since he's been home, he's tested positive for barbiturates, THC, cocaine. When he's not taking his medicine like he's supposed to. And we've talked about that. We've discussed that. He's diagnosed with schizophrenia. And he knows that when he doesn't take his medicine, he starts drug seeking. The last time he
Are you
tested.
getting your medicines? Okay.
In county, I'm getting it about 2/3 of the time,
Really?
and they're
What's the,
not giving me the afternoon dose.
sir?
I'm not getting the noon dose. In about 30 minutes, I'm not getting.
Do they know about it?
Yeah. Yes, sir. Yes, Your Honor.
Did you tell your attorney?
We were just able to talk for the first time since I've been locked up a few minutes ago.
Yeah.
Things have been fairly rushed.
I'm sorry, you've been locked up a few minutes ago?
I was only able to speak to him since I've been locked up a few minutes ago.
How long have you been locked up?
About 2 months, almost 2 months.
He's not seen you in 2 months?
Yes, Your Honor.
What about that? What are you figuring out that you need? I mean, does he need some medicine?
Well, I know that he was previously on Cogentin. And
What about right now? What do you know about him? You hadn't seen him in 2 months, but what do you know?
as far as what he's presently taking at the jail, I don't know.
Can you figure out? So we know he's getting medicine
Yeah,
like he should,
Thorazine, Buspar, and benzotropin.
sir?
Thorazine, Buspar, Buspirone, and benzotropin.
When you're getting the medicine, do you feel okay?
Normally, yes.
Okay. Anything else, Dan? Then his bond is $20,000. If you post your bond, you need to have a drug patch as a condition of bond so that we know if you're using any drugs. And that it has to be done as a condition. And you have to be taking all your medicine as a condition.
Mr.
You know, the probation officer tells me that at least one of those positive tests was on a drug patch when he was on probation.
Failure is not an option.
Mr. Honor.
I would do it, but anyway, I'm setting this for a hearing next week.
Mr. Honor.
Thank you. All right, is that? I have,
I don't have a file. Oh, I just said it for.
I have 2 cases. What are we doing?
MTRP is, well, both of them we planned, MTRP is 127, Big True, county time. Revocation, dismiss on these things. That's right. I forget that.
We're actually resolving 3 cases today.
There's most of you are above probation here, 25 CR 2092. Raise your right hand and solemnly swear or affirm any statement you make during this hearing of the truth, the whole truth, and nothing but the truth. So help you. Can we proceed, son?
Yes, Judge.
In summary, this motion states that on June 16th, 2025, in this court, you were sentenced to 1 year in the county jail, probated for 2 years for a Class A misdemeanor of theft. Is that true?
Still need to count, approve on count one, Judge.
One states you committed the offense of theft of property, which I guess. No, it's not this one. The offense of theft of property on or about September 23rd, 2025. You see, that's not going to help us because we're going to have to go through all the elements of it to prove them up. And just, it's going to have, the police going to have to support all the elements. I've got this new indictment, I think, with possession of controlled substance. She pleaded guilty to that. Okay, is that?
Second degree.
I'm sure it's not right.
Right, because.
That offense predates her probation.
Just pleading guilty, that's all I'm saying.
If the court is all right with something other.
Yeah.
Or she's got,
Provided a urine sample on or about September 16th, 2025 that showed the presence of marijuana and methamphetamine in violation of condition 10 of your probation order. Is that true or untrue? Are you pleading true voluntarily and because it is true as it is alleged? You understand that voluntary and knowingly made plea of proof of one or more violations of probation is all it takes to grant this probation? To grant this motion to revoke probation, your probation can be revoked. You can be sentenced to 1 year in county jail, knowing that, and you insist on pleading to that. Yes.
Yes, sir.
I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading.
Yes, sir.
number three.
Three, no, sir.
The agreement's been reached, you would be sentenced to 1 year in the county jail. Is that your understanding of the agreement? If I follow that, you have no right of appeal. Do you understand?
I'll tell her to take a second. I'll mention them.
Anything else? I'm going to follow this agreement and find that there is sufficient evidence supporting this motion to grant it by preponderance of the evidence or greater. The defendant has knowingly and voluntarily pleaded true to allegation number 3, which is a violation of condition 10 of the probation order by providing a urine sample showing the presence or possession of marijuana and methamphetamine. That supports this motion by a preponderance of the evidence or greater. Thus, your probation is revoked and you were hereby sentenced to confinement in the county jail for 1 year. You will be given credit for all time you have served in accordance with that. So you understand what's happened there.
Yes, sir.
Then what's
I'll touch the screen.
she pleading to 1293?
Yes, sir.
That's what we use.
Does the defendant, who's here with Mr. Turk, our attorney, waive a formal reading of this indictment and arraignment? Can we proceed in summary?
Yes, we may, Judge.
In summary, this indictment alleges that on or about September 4th, 2024 in Jefferson County, Texas, you committed the second-degree felony of illegal possession of a controlled substance, namely methamphetamine. Do you understand what you're charged with here?
Sir.
If convicted of second-degree felony, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached in your case where you would be pleading guilty, sentenced to 10 years in prison. We're putting on a regular probation.
Straight probation.
10 years in prison, that would be suspended. You're placed on regular probation for 10 years. There would be terms and conditions of probation which you have had trouble following. That would be necessary, or else your probation could be revoked and you could be sentenced up to 10 years in prison. Do you understand what the plan is?
Yes, sir.
If I follow this, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead to this? Guilty or not guilty? You're pleading guilty voluntarily and because you are guilty. Show you what's most. States Exhibit 1, did you sign that? Understand it? Discuss it with your attorney? Is everything true and correct?
Yes, sir.
States Exhibit 1 tendered. Without objection. This states you are mentally competent at the end of your guilty plea. It's freely and voluntarily made. We know what you've been charged with. The indictments we go to you wrote. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to verify and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All of this is true, so help you God.
Yes, sir.
Pre-sentence reports waived.
Yes, sir.
Nothing further. I'm going to find you are pleading guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence from States Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this second degree felony of illegal possession of a controlled substance named methamphetamine. I'm following the agreement, hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. That is suspended. You were placed on regular probation of 10 years. There will be terms and conditions of probation, which will be reviewed with you by the probation office. Please make sure you follow them. They are important. If you fail, again, you know, your probation could be revoked and you could be sentenced up to 10 years in prison. Thank you. Anything else?
The state's going to dismiss
I'm
the.
gonna dismiss all over for you.
All right.
As a misdemeanor.
Thank you. That's all.
Well, prosecutor will give her time, so.
He's about to.
So that.
Let's get ready.
She needs to get that done or else it was slow.
Okay. You said today.
So you are Maximo Urbina?
Yes, sir.
All right. In 25 CR 53 here, this indictment, as you probably know, you have been indicted for the third degree felony of evading arrest or detention with a motor vehicle. And this occurred, it states in the indictment on or about November 6th, 2024. That's a third degree felony, which carries with it, if convicted, no less than 2, no more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand what you're facing?
Yes, sir.
It doesn't end there. You have a rich criminal history. So in 2002, the state you were convicted of robbery out of Harris County and sentenced. Thereafter, that robbery was final. It is alleged you committed burglary of a habitation and were convicted of that in 2008 in Harris County, Texas. That right there, those two, robbery and burglary, place you in a situation where you are looking at habitual felon status. But looks like you have 2 other convictions after that. In 2016, you were convicted of evading arrest or detention with a motor, evading arrest or detention with a motor vehicle, which is interesting. It's the same type of crime you were charged with in this case. And also indecency with a child, you were convicted also on that same day. And those are out of district courts in Harris County. So you were a habitual felon 2 convictions ago. And here you are. So you're looking at no less than 25 years in prison to life in prison. Do you understand the punishment range that you face because of all of this? So with all that, he understands. What do we do?
Judge, he has expressed to me that his wife will be hiring him in a different attorney by the end of this week, isn't that what you told me? Okay, soon. She will be hiring a different attorney soon.
Yes.
Mr. Ham has extended an offer. We had discussions and that offer started at 25, which was the minimum of that habitual status range that he was looking at. Through discussions, Mr. Ham has agreed to abandon those enhancements and just give him 10, which was within the punishment range for a third-degree felony. We've talked about those offers. He knows what that looks like, and I've explained that to him, but in our discussion today, he has expressed that he wishes to hire another attorney.
Yeah. Okay, so he signs an affidavit of indigence over a year ago. And one of the justice of the peace is here. It's
Which is usually done intake.
no, I know that's not the point is then I only see 2 resettings in November and December after he was appointed. He for a year nothing happens for 1 year on this on Obama. What happened? I don't. There are no resettings except it jumps up to November.
Judge, he was bench warranted here from TDC. So I'm not sure what that process looks like in terms of.
See,
He was sent,
he was indicted over well going on a year here.
Yes.
And
Judge, he was arrested here, he was sent, it was released to another agency. So someone came and got him after he was only here for about 8 days back in November.
where'd you go?
24.
You know,
Montgomery County Circuit.
Montgomery.
And then,
They sent him to TDC, I believe. And then he came here from TDC.
All right. Well, what we're gonna yeah. What we're gonna do is he can get another lawyer, but I'm putting it on the trial docket. We're just gonna default it over to the trial docket. No deal. Don't want a deal. I'm not gonna get one. Let's try this case as soon as somebody can handle it. And if you hire somebody, that's great. Otherwise, we're gonna move forward to trial. You understand? I'm not gonna wait. It's been 2 months. We're just waiting around. And that's not the way we do things. We move forward.
I've advised his current lawyer that the offer that I extended is
Revoke.
it's withdrawn.
Okay, so there is no deal now. We're just gonna go to trial. We'll set it for trial, and if you can get somebody, fine, but they gotta be ready to go to trial. I'm not gonna wait around. You've had a year to get ready.
I was in custody.
Yeah, so what? You go and get a lawyer if you need to, but now you're asking for a lawyer. You're still in custody. Now you want more time. You've had a year. It's time to move forward. We move forward. We go forward, not lollygag. Okay? Set for trial. Set for trial. Set. For- All right. Crystal Vaughn. 25 CR 40. 25 CR 497 is now called the State of Texas versus Carson Moore. Is that you? Yes, sir. Present with your attorney, Mr. Turk, and the state's attorney. Does the defendant with a formal reading of this indictment and arraignment, can we proceed in silence? In summary, this indictment alleges that on or about February 14th, 2025 in Jefferson County, Texas, you committed the second-degree felony of assault on a peace officer. Do you understand what you're charged with here?
Judge, let's make sure we're clear. This is going to be a lesser included of assault.
Do you understand what you're charged with in the indictment?
Yes, sir.
All right. That would be a second-degree felony. You have an agreement that I'm looking at that states you would be pleading guilty to the lesser Class A misdemeanor of assault, which carries with it up to 1 year in the county jail and or a fine up to $4,000. Is that your understanding?
Yes.
You're looking over at him. But you understand the punishment range and what the plan is.
Yes, sir.
Okay. An agreement has further been reached. You would be pleading guilty to this class A misdemeanor and placed on 2 years deferred unadjudicated probation. Correct?
Yes, sir.
So if I follow this agreement, you have no right of appeal. You understand?
Yes, sir.
How do you plead to this, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily?
Yes, sir.
That is on your own free will and because you are guilty.
Yes, sir.
Show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Did you understand it, discuss it with your attorney, or the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence without objection admitted. The states you were mentally competent to enter your guilty plea, which is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You read it. You are guilty of the crime charged and any lesser included offenses. You are giving up your right to a jury trial and the right to the appearance, confrontation, cross-examination of witnesses. Are you totally satisfied with the representation provided by your lawyer? All of this is true, so help you God.
Yes.
State's Exhibit 1, part of the record for all purposes. Pre-sentence report, right?
Yes, Judge.
Multitasking here and writing on the indictment. You have pleaded guilty to, which is the lesser included class A student. All right, I'm going to follow this agreement and find you are mentally competent to enter this guilty plea to this lesser included class A misdemeanor of assault. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea. State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt of this lesser included class A misdemeanor of assault. However, I'm going to instead defer any finding of guilt and place you on deferred or unadjudicated probation for 2 years. There will be terms and conditions of probation for this misdemeanor assault, not the least of which is you shall complete an anger management program. That's directing, which helps you make cool choice decisions when you're under pressure, which I think is behind all of this. And other terms and conditions of probation. Make sure you follow them. If you fail, your probation could be revoked. You could then be found guilty and sentenced up to 1 year in the county jail. Okay. You understand what's happening? Please see the probation office.